Alam mo, ang ganda mo pala pag tumawa ang iyong mata. Hinahabol ko ang bawat mong tingin, ngunit ito'y di mo napapansin. Wala akong maipagmamayabang, porma ko'y pasimple-simple lang. Sino ba ako? Walang dating sa'yo, di tayo bagay, sobrang mong ganda talaga. Di ko alam hanggang kailan tayo, di ko mabago ang ikot ng mundo, pero sama ka sa aking biyahe. Atin lamang ang araw na ito, ang buhay ay sinasakyan lang iyan. Di ko alam ang tungo kung saan, pag sumama ka sa aking biyahe. Iaalay ko ang puso ko. Okay, sarap mong kasama, napapawi mga problema. Magkaan dalhin, kay sarap ang bingin, yun nga lang ay kaibigan kita. Akala ko mapipigil ko, bakit lalong nahuhulog sa'yo? Nang iyong nabuking tinanong sa'kin, dapat nung pagbigyan pag-ibig natin mahalin. Di ko alam hanggang kailan tayo, di ko mabago ang ikot ng mundo, pero sama ka sa aking biyahe. Atin lamang ang araw na ito, ang buhay ay sinasakyan lang iyan. Di ko alam ang tungo kung saan, pag sumama ka sa aking biyahe. Iaalay ko ang puso ko. Sa iba ito'y laro lamang, away-away puro selos lang. Ang iba'y nagsisisi, sabi sarado'y wag ko raw pasukan. Ba't naman di ko alam hanggang kailan tayo, di ko mabago ang ikot ng mundo, pero sama ka sa aking biyahe. Atin lamang ang araw na to, ang buhay ay sinasakyan lang iyan. Di ko alam ang tungo kung saan, pag sumama ka sa aking biyahe. Iaalay ko ang puso ko. Iaalay ko ang puso ko.
All right. So, hello everyone. So, this is my kind of study. This is just for my memory for the upcoming prelim exam for persons and family relations. So, our coverage will be on the Civil Code of the Philippines, Republic Act number 386, from Article 1 to Article 47. So let me guide you through this. I'm using Paras, the book of Paras as a reference. So preliminary title, Chapter 1, Effects and Application of Laws. So Article 1 states that this act shall be known as the Civil Code of the Philippines. So where does this Civil Code came from, or the sources of the Civil Code? So we have the Civil Code of Spain, we have the Philippine Constitution of 1935, we have the statutes or laws, Philippine, American, or European. Then we have also the rules of court, local and foreign. We have also the decisions of local tribunals, particularly the Supreme Court, decisions of foreign tribunals. Then we have also customs and traditions of our people. Then general principles of law and equity, and ideas from the Code Commission itself. Right, so let me run through this and go to Article 2. We do not have much discussion on Article 1. It just states there that this is the Civil Code of the Philippines. Alright. So, Article 2. Article 2, laws shall take effect after 15 days following the completion of their publication in the official Gazette unless it is otherwise provided. This code shall take effect 1 year after such publication. So the scope of the article on effectivity of laws. So this article provides for the effectivity of two kinds of law. Namely, we have an ordinary law and we have the civil code. So when the country is placed under martial law, the lawmaking authority is ordinarily vested in the chief executive or the president-commander-in-chief, who usually issues. So we have these general orders, we have presidential decrees also, and letters of instructions or letters of implementation. So we have proclamations. So in this case, Tanyada versus Tavera on December 29, 1986, the Supreme Court cannot rule upon the wisdom of the law to repeal or modify if it finds it impractical. That is not its function. The function belongs to the legislature. The task of the Supreme Court is merely to interpret and apply the law as conceived and approved by the political departments of the government in accordance with prescribed procedure. So when does the effectivity date of an ordinary law? An ordinary law take effect A, on the date it is expressly provided to take effect. If no such date is made, then after 15 days following the completion of its publication in the official Gazette. The Article 2 states that, or in a newspaper of general circulation. Again, the effectivity date of an ordinary law or a law, it's on the date it is expressly provided. When there's no express date, so it is the made or take effect then after 15 days following the completion of publication. So where it will be published in the official Gazette or in a newspaper of general circulation. So when no publication is needed, where a law provided for its own effectivity, such as, for example, July 4, 2002, or upon approval, the President or by Congress over the veto of the President's publication in the official Gazette is not necessary so long as it is not punitive in character. This was the rule initiated by the Supreme Court in Askay versus Kasalan. When publication is needed, unless otherwise provided, the law shall take effect after 15 days following the completion of the publication in the official Gazette. Tanyada versus Tavera, again, the publication has been full or it is no publication at all, since its purpose is to inform the public of the contents of the law. It must be made in the official Gazette and not elsewhere. As a requirement for the effectivity after 15 days from such publication or after a different period provided by the legislature. The rules applicable to certain circulars, but not to all. That is in the case of People versus Populi. Run through with that. Go over with the Tanyada versus Tavera issue. The circular issued by the Monetary Board must be published if they are meant not merely to interpret but to fill in the details of the central bank RA number 265, which the body is supposed to enforce. Do this. And also Article 3. Article 3 states that ignorance of the law excuses no one from compliance therewith. The Latin maxim on this article is um, found here. It's ignorantia lihis non excusa, meaning ignorance of the law excuses no one. Right? So when is the applicability of this maxim? Article 3 states that it applies to all kinds of domestic laws, whether civil or penal, and also whether substantive or remedial. We talk about penal laws, so a law prescribing a penalty, as for example, fine or imprisonment for one who violates it. And if you go over with the substantive or remedial law, substantive law is that which creates, defines, regulates, and extinguishes rights and obligations. So remedial law is that law which provides the procedure or remedy for enforcement of rights and obligations through the court of justice. So again, the applicability of this maxim, Article 3, states that it applies to all kinds of domestic laws, whether again penal or substantive or remedial. So ignorance of foreign law is not ignorance of the law, but ignorance of the fact, because foreign laws must be alleged and proved as matters of fact, there being no judicial notice of said foreign law. If the foreign law is not properly alleged and proved, the presumption is that it is the same as our law. So this presumption has been referred to by the farm author as procedural presumption. For example, that a marriage in China celebrated before a village leader therein cannot be recognized as valid in the Philippines unless there is proof that indeed in China and according to Chinese law, such a marriage is regarded as valid. Without such proof, you will assume that the law on marriage in China is the same as the law in the Philippines. And in our country, it is well known that a village leader cannot perform a marriage whether before or after the effectivity of the new civil code. Where so to Article 4. Article 4, law shall have no retroactive effect unless the contrary is provided. So reasons why law in general are prospective. In general, laws are prospective, not retroactive. It is always going forward and not goes backward. While the judge looks backward, the legislator must look forward. So if the rule was that laws were retroactive, grave injustice would occur, for these laws would punish individuals for violations of laws not yet enacted. While ignorance of the law does not serve as an excuse, such ignorance refers only to laws that have already been enacted. Then, if the law is going forward, so we have so-called exemptions to the prospective effect of laws. So while in general, laws are prospective, they are retroactive in the following cases. First, if the law themselves provide for retroactivity. If the law provides, or expressly provided retroactivity, then the law is going retroactive. So, but in no case must an ex post facto law. Ex post facto is something done afterward. In a legal context, ex post facto is most typically used to refer to a criminal statute that punishes action retroactively, thereby criminalizing conduct that was legal when originally performed. So, law be passed. So, generally, the Philippine Constitution does not prohibit retroactive law. An example of an ex post facto law is the one that makes criminal and punishable an act done before the passing of the law and which was innocent when done. Second, if the laws are remedial in nature, the reasons there are no vested rights and rules of procedure. Third, if the statute is penal in nature, provided that it is favorable to the accused or to the convict. Second, and provided further that the accused or convict is not a habitual delinquent, the term defined in criminal law. If the law is curative, it is necessarily retroactive for the precise purpose is to cure errors or irregularities. However, this kind of law to be valid must be imper- impervised rights nor effect final judgment, and if substantive rights to be declared. Article 5. Acts executed against the provision of mandatory prohibitory law shall be void except when the law itself authorizes their validity. So these laws talks about mandatory or prohibitory laws. So it should be noted that Article 5 refers to mandatory. If we talk about mandatory laws, laws are laws that are imperative and impose a duty upon those covered by the law. Generally, these laws contain the word shall or must. Acts contrary to mandatory laws are void unless there is an exemption in the law. Prohibitory laws, however, are mandatory laws that imposes duties that refrain from doing or forbidding. So laws as distinguished from those which are merely permissive, where one has to obey a mandatory statute, otherwise this act would generally be void, then the violation of directory law cannot result in valid act. Kinds of mandatory legislation, like penal and some contractual law. Positive law, so when something must be done. Negative or prohibitory, when something should not be done. Example, generally in order to be valid, a simple donation in the vehicles of a part of the plan must be in a public instrument. If orally made or if effectuated in a private instrument, the donation is null and void. Article 6. Rights may be waived unless the waiver is contrary to law, public order, public policy, morals or good customs, or prejudicial to the third person with the right recognized by law. So rules for the waiver of rights. Talks about the general rule, rights may be waived. Exemption. When the waiver is contrary to law, public order, public policy, morals, or good customs. Second, when the waiver is prejudicial to the third person with a right recognized by law, unless, of course, such waiver has been made with the consent of such third person. Requisites for a valid waiver. The person waiving must be capacitated to make the waiver. Hence, the waiver by a minor or by an insane person or non-compos mentis is voidable. So the person waiving must know such right. B. The waiver must be made clearly, but not necessarily expressed. Third, the person waiving must actually have the right which he is renouncing, otherwise he will not do anything. D. In certain instances, the waiver, as in the express remission of the debt owed in favor of the waiver, must comply with the formalities of the Next, the waiver must not be contrary to law, morals, public policy, the aims. Then the waiver must not prejudice the understanding of the law. So these are examples of rights that cannot be renounced, cannot be waived. First is natural rights, and that's the right to life. Therefore, if a person requests another one to kill himself, the killer would still be criminally liable. As a matter of fact, even if a person is not the killer himself, if a person assists another in the latter's suicide, the helper is penalized with the penalty of prison major. The right to be supported, present or future support cannot be renounced for support is vital to life and the future. That's the reason why euthanasia is not allowed in our country. Second, alleged rights which really do not yet exist. Future inheritance cannot be renounced since no right is vested till the death of the decedent. Next, those the renunciation of which would infringe upon public policy. Then, when the waiver is prejudicial to the third person with a right recognized by law. So while the heir may renounce present inheritance that has already accrued by virtue of the decedent's death, still if the waiver will prejudice existing creditors, the latter can accept the inheritance in the name of heir, but only to the extent sufficient to cover the amount allocated. Then we have here examples of rights that may be renounced. First, we have support in arrears, for evidently this is no longer needed for subsistence. Second, the right granted to prepare at least 2 days before trial is waivable, let's say, or impliedly. It can be implied from the failure to ask for sufficient time to prepare for trial. Then we have the right to object to testimony of a wife or information obtained because of her domestic relations with her husband is waived. When husband accused of killing his son does not only deny his guilt but also points to the wife as the killer. So in the prosecution for rape against his own child, the husband cannot object to the testimony given by his wife against him. For in effect, this may be considered as an offense committed by the husband against his wife. Then the right of the accused to be held by counsel may also be waived, provided the judge informs said accused of his right. Then we have the rights of the accused in a criminal case to have criminal investigation may be waived. Venue of action, then we have also tax obligations of living extinguished. An individual who accepts the office of an executor or administrator may waive petition, therefore, in the right to be back pay if employee who has been dismissed without justifiable cause to be waived by him. It is particularly so when he has been put back to work. Let's go over and let's go to Article 7. Article 7. Laws are repealed only by the subsequent one, and their violation or non-observance shall not be excused by the disuse or custom or practice to the contrary. When the courts declared a law to be inconsistent with the Constitution, the former shall be void and the latter shall govern. Administrative or executive acts, orders, and regulations shall be valid only when they are not contrary to the law or the Constitution. So how laws are repealed? Laws are repealed expressly or impliedly. If expressly repealed, the statute expressly mentioned that an earlier law will no longer be applicable after the it is stated. Implied, in the other hand, a statute which is inconsistent with the earlier statute, so the both cannot be applied, is taken to have impliedly repealed the relevant provisions of the earlier statute. So insofar as there are inconsistencies between a prior and a subsequent law, Article 8. Article 8. Judicial decisions applying or interpreting the laws or the Constitution shall form part of the legal system of the Philippines. So are judicial decisions laws? While it is true that decisions which apply or interpret the Constitution or the laws are part of the legal system of the Philippines, still they are not laws. If this were so, the courts would be allowed to legislate contrary to the principle of separation of powers. Indeed, the courts exist in order to state what the law is, not for giving it. There have been instances, however, when the Supreme Court has made rules a judicial state that render decisions not based on law or custom. So, go over to the doctrine of stare decisis. In the Philippines, we adhere to the doctrine of stare decisis, meaning to let it stand. For reasons of stability in the law, the doctrine which really adherence to the precedent states that once a case has been decided one way, in another case involving exactly the same point at issue should be decided in the same manner. Of course, when a case has been decided erroneously, Such an error must not be perpetuated by blind obedience to the doctrine of stare decisis. No matter how sound a doctrine may be, and no matter how long it has been followed through the years, still, if found to be contrary to law, it must be abandoned. The principle of stare decisis does not and should not apply when there is a conflict between the precedents and the law. While stability in the law is eminently to be desired, idolatrous reverence for precedents simply as precedent no longer rule. More pregnant than anything else is that the court shall be right. Obiter dictum. Obiter dictum are opinions not necessarily to the determination of the case. They are not binding and cannot have the force of judicial precedents. It has been said that an obiter dictum is an opinion uttered by the way and not upon the point of question pending. It is as if the court were turning aside from the main topic of the case to collateral subjects. And let's go to Article 9. Article 9. No judge or court shall decline to render judgment by reason of the silence, obscurity, or insufficiency of the laws. So the duty of a judge, if the law is silent, a judge must give a decision whether he knows what law to apply or not. Thus, even if a judge does not know the rules of cockfighting, he must still decide the case. Accordingly, the judge may apply any rule he desires as long as the rule chosen is in harmony with the general interest, order, morals, and public policy. Among such rules may be following: custom which are not contrary to law, public order, and public policy. Second, decisions of foreign and local courts on similar cases. Third, opinions of a highly qualified writers and professors. Fourth, rules of statutory construction. Fifth, principles laid down in the analogous instances. Thus, it has been said that there were laws governing particular matter is silent on a question of issue. The provision of another law governing another matter may be applied where the underlying principle or reason is different. Article 10. Article 10. In case of doubt in the interpretation or application of laws, it is presumed that the lawmaking body intended right and justice to prevail. So the maxim is dura lex sed lex. The law may be harsh, but it is still the law. Hence, the first duty of the judge to apply the law, whether it be wise or not, whether just or unjust, provided that the law is clear, there is no doubt. It is the sworn duty of a judge to apply the law without fear or favor, to follow its mandate, not to tamper with it. What the law grants, the court cannot deny. For some laws are unwise and detrimental, proper representations may be made to Congress. Be it observed that our courts are referred to as courts of law, not necessarily justice. In case of doubt, the judge should presume that the lawmaking body intended right and justice to prevail. After all, it has been truly said that we should interpret not by the letter that killeth, but by the spirit that giveth life. Thus, also literally under Act number 2747, only a mortgagor may redeem foreclosed property. The word was construed to include a legal heir to the mortgagor, otherwise gross injustice might result. Judicial conclusions inconsistent with the spirit of the law must be avoided. Moreover, it has been wisely stated that when the reason for the law ceases, the law automatically ceases to be one. Article 11. Article 11. Customs which are contrary to law, public order, public policy shall not be countenanced. Custom. Let us define custom. A custom is the rule of human action, conduct, established by repeated acts and uniformly observed or practiced as the rule of society. through the implicit approval of the lawmakers, and which is therefore generally obligatory and legally binding. Simpson's Law Dictionary defines the custom of a place as that which is brought about by local usage, and it's not annexed or peculiar to any particular individual. The requisites before the courts can consider customs. A custom must be proved as a fact according to the rules of evidence, otherwise, the custom cannot be considered as a source of right. Thus, there is no judicial notice of custom. Second, the custom must be contrary to law, public order. Must not be contrary to law, public order, or public policy. Third, there must be a number of repeated acts. Fourth, the repeated acts must have been uniformly performed. Fifth, there must be juridical intention to make the rule of social conduct. There must be a conviction in the community that it is the proper way of acting and that, therefore, the person who disregards the custom in fact also disregards the law. And there must be a sufficient lapse of time. This by itself is not a requisite of custom, but it gives evidence of the fact that indeed it exists and is being duly observed. Article 12. Article 12. Custom must be proved as a fact according to the rules of evidence. Presumption of acting in accordance with custom. There is a presumption that a person acts according to the custom of the place. Article 13. Article 13. When the law speaks of years, months, days, or nights, it shall be understood that years are of 365 days each, months of 30 days, days of 24 hours, and nights from sunset to sunrise. If months are designated by their name, they shall be computed by the number of days which they respectively have. In computing a period, the first day shall be excluded and the last day included. Example of how periods are computed. So 10 months is equal to 300 days. 1 year is to 365 days. March has 31 days because a month is specifically designated. And also, Article 14. Penal laws, those of public security and safety, shall be obligatory upon all who live or sojourn in the Philippine territory, subject to the principles of public international law and to treaty stipulation. Article 14 states that the states their theories of territoriality and generality. So we adhere in the Philippines to that doctrine in criminal law known as the theory of territoriality. The offense committed within our territory offends the state. Therefore, any person, whether citizens or alien, can be punished for committing a crime here. Thus, the technical term generality came into being. It means that even aliens, male or female, come under our territorial jurisdiction. This is because aliens owe some sort of alliance, even if it's temporal. Exemption. Article 14 recognizes two exemptions. First, the principles of public international law. Examples are the immunities granted to diplomatic officials and visiting heads of state, provided the latter do not travel incognito. If you travel incognito, but with the knowledge of our government officials, heads of the states are entitled to immunity. If the incognito travel is without the knowledge or permission of our country, diplomatic immunity cannot be insisted upon, and the heads of the state traveling will be arrested. However, once they reveal their identity, immunity is given. Generally, should a friendly foreign army be given permission to march to our country or to be stationed here, then the army is usually exempt from civil and criminal responsibility, because heads of states are immune. Secondly, the presence of treaty stipulation. Thus, we have a Philippine-United States military base agreement dated on March 14, 1947, which contains some provisions exempting certain members of the armed forces of the United States from the jurisdiction of Article 15. Article 15. Laws relating to family rights and duties or to the status, condition, and legal capacity of persons are binding upon citizens of the Philippines, even though living abroad. Status defined is the status of a person in civil law, includes personal qualities and relations more or less permanent in nature and not ordinarily terminable at his own will, such as his being married or not, or his being legitimate or illegitimate. In Goodyear's Law Dictionary defines status as the sum total of a person's rights, duties, and capacity. Such as Roman considers civil status a distinct consideration of a person before the civil law. Scope of Article 15. It is talking about the nationality principle. Article 15 refers to first, family rights and duties, including parental authority, marital authority, support. Second, status. Third, condition. And fourth, legal capacity. There are various exemptions, judicial on legal capacity. Applicability of Article 15. Article 15, which is a rule of private international law or a conflict rule containing, as it does, a reference to a foreign element, such as a foreign country, stresses the principles of nationality. Some other countries like Great Britain and the United States stress the principle of domicile. Capacity to enter into ordinary contract. Capacity to enter into ordinary contract is governed by the national law of a person, not by the law of the place where the contract was entered into. This is talking about Lex Luce Celebrationes, an erroneous pronunciation by the Supreme Court in the case of Government versus France. Then Article 16. Article 16 talks about real property as well as personal property is subject to the law of the country where it is situated. However, intestate and testamentary successions, both with respect to the order of succession and to the amount of successional rights and to the extrinsic validity of the testamentary provisions, shall be regulated by the national law of the person whose succession is under consideration, whatever may be the nature of the property and regardless of the country wherein said property may be found. So complex rules on property. So we have here a doctrine, a maxim of lex re state. Property, whether real or personal, is as a rule governed by lex re state, meaning law of a place where the property is situated. It is inevitable that the rules should be thus for real property, for after all, real property is attached to the land, and a contrary rule may be rendered a judgment on the land ineffective or incapable of enforcement. So we have also here a doctrine of mobilia sequitur persona, which is changed into the maxim of lex re state. However, now there has been a great increase the amount and variety of personal property not immediately connected with the person of the owner. It was deemed advisable by the Congress of the Philippines to adopt the doctrine of lex re state also to movables, talking about real and movable property. Applications of the doctrine of lex re state. So we have shares of stocks of foreigner, even if personal property can be taxed in the Philippines so long as the property is located in this country. Bank deposits in the Philippines, even if it belongs to a foreigner, will be the subject of attachment proceeding. Taxes may be imposed on dividends from shares in a gas corporation situated in the Philippines, even if the stockholder cannot be found. Exemptions to the lex situs rule. One is the important exemption to the lex situs rule, of course, in the case of successional rights. Thus, the following matters are governed not by lex situs but by the national law of the state. We have the order of succession, the amount of successional rights, intrinsic validity of the provisions of the will, and the capacity to succeed. Then we go to the renvoi. Renvoi literally means referring back. The problem arises when there is doubt as to whether a reference in a law, such as Article 16, Paragraph 2 of the Civil Code, to a foreign law such as national law of the disuse, is a reference to the internal law of the said foreign law. It is a reference to the whole of the foreign law, including the contract rules. Go over Article 17. Article 17 states that the forms and solemnities of contracts, wills, and other public instruments shall be governed by the law of the country in which they are executed. When the acts referred to are executed before the diplomatic or consular officials of the Republic of the Philippines in a foreign country, the solemnities established by the Philippine law shall be observed in their execution. Prohibitive laws concerning persons, their acts or property, and those which have for their object public order, public policy, and good customs shall not be rendered ineffective by laws or judgment promulgated or by determinations or conventions agreed upon in a foreign country. So we have doctrine of lex luce celebrationes. The first paragraph of the article lays down the rule of lex luce celebrationes insofar as intrinsic validity or forms and solemnities is concerned. Because a contract entered into by a Filipino in Japan will be governed by Japanese law insofar as forms and solemnities of the contract are concerned. Thus, also, if a power of attorney is executed in Germany, German laws and not our civil code should determine its formal validity. Then let's go to the rule of exterritoriality. Exterritoriality. Even if the act be done abroad, still if executed before the Philippine diplomatic and consular officials, the solemnities of the Philippine law shall be observed. The theory is that the act is being done within an extension of the Philippine territory. Philippine principle of exterritoriality. Rule respecting prohibitive laws. The third paragraph gives one exemption to the rule that a foreign law, contract, or judgment can be given effect. The reason is that public policy in the Philippines prohibits this. Intrinsic validity of contract. It should be noted that while in the first paragraph of Article 17 speaks of forms and solemnities, no mention is made of the law that should govern the intrinsic validity of contract. In general, the prevailing rule in private international law today is to consider the lex luce voluntatis, the law of the place, voluntarily selected, or the lex luce intentionis, wherein the law of the place intended by the parties to the contract. Let's go to Article 18. Article 18 in matters which are governed by the Code of Commerce and special laws, their deficiency shall be supplied by the provisions of this code. Rule in case of conflict between the civil code and other law. In case of conflict with the Code of Commerce or special law, the civil code shall only be supletory, except if otherwise provided for under civil code. In general, therefore, in case of conflict, the special law prevails over the civil code, which is general in nature. Then let's go to chapter 2. It talks about human relations. Let us start with Article 19. Article 19 states that every person must, in the exercise of his rights and in the performance of his duties, act with justice, give everyone his due, and observe honesty and good faith. So why the Code Commission formulated the chapter on the human relations? The chapter on human relations was formulated to present some basic principles that are to be observed for the rightful relationship between human beings and the stability of the social order. The lawmaker makes it imperative on everyone to respect the rights of others. Indeed, this chapter is calculated to indicate certain norms that spring from the fountain of good conscience. These guides for human conduct should run as golden threads through society to the end that the law may approach its supreme ideal, which is in its way of and dominance of justice. Stress of this article. This article stresses acting with justice, give everyone his due, and observe honesty and good faith. Thus, rights must never be abused. The moment they are abused, they are ceased to be right. So this article talks about the abuse of rights. So what do you mean by acting with justice and giving another due? This is elaborated in the following article. So among others, let us remember that Article 20 talks about indemnification of another due to illegal act. In Article 21 is the indemnification due to immoral act. And then Article 24 talks about unfair competition. Article 22 talks about unjust enrichment. The observance of honesty and good faith. This is elaborated in the following articles, among others. Article 26, respect for the personality and dignity of others. Article 25 talks about restraint of undue extravagance. Article 31, independent civil action. And what do you mean by honesty? Honesty, careful regard for others' rights and property. Good faith means honest intention to avoid taking undue advantage of another. And let's go to Article 20. Article 20, every person who, contrary to law, willfully or negligently causes damage to another shall indemnify the latter for the same. They talk about willful or negligent acts. The article punishes illegal acts whether done willfully or negligently. Thus, in the law of torts and quasi-delicts, whoever by act of omission causes damage to another, there being faults or negligence, is obliged to pay for the damage done. This is the law of quasi-delicts. Let's go to Article 21. Article 21, any person who willfully causes loss or injury to another in a manner that is contrary to morals, good custom, or public policy shall compensate the latter for the damage. Willful acts contrary to morals. Would not Article 21 obliterate the boundary line between morality and law? The answer is that in the last analysis, every good law draws its breath of life from morals, from those principles which are written with words of fire in the conscience of men. Furthermore, there is no belief or more baneful consequence upon the social order than that a person may with impunity cause damage to his fellow men so long as he does not break any law of the state. Though he may be defying the most sacred postulates of morality, what is more, the victim loses faith in the ability of the government to afford him protection or relief. Article 21 was intended to expand the concept of torts in this jurisdiction, granting adequate legal remedy for the untold number of moral wrongs. This is impossible for human foresight to specifically provide it. Article 21 distinguished from Article 20. Article 21 talks about the act is contrary to morals, to custom, or public policy, while Article 20 the act is contrary to law. Article 21, the act is done willfully. Note, willful may mean not merely voluntary, but with bad purpose. Article 20, the act is done either willfully or negligently. That's how you will distinguish Article 20 from Article 21. Then there is a question, can there be an action for the breach of promise to marry? So for the recovery of actual damages, yes, but for the mere breach of promise to marry, there is no law from punishing it. Thus, if a person gives another 500, which is an example because the latter promise to marry, the former promise is not fulfilled, the money given can be recovered. And also, thus, if a teacher resigns from her position because of the man's promise to marry her, she can recover indemnity for damages if latter and the promise is not fulfilled. Same thing may be said for the recovery of wedding expenses, such as wedding breakfast and ceremony that results to ignorance and invitation of one party to appear. Bar question. In action based on the breach of promise to marry, what rights has the aggrieved party in cases? For example, when there has been carnal knowledge and when there has been no carnal knowledge. Answer. When there has been carnal knowledge, the aggrieved party may First, ask the other to recognize the child, should there be one, and give support to the entire child. Two, sue for moral damages if there be a criminal or moral seduction, but not if the intercourse was due to mutual lust. In other words, if the cause may be promised to marry, an effect may be carnal, and the effect be the carnal knowledge, there is a chance that there was a criminal or moral seduction. Hence, recovery of moral damages will prosper if it's the other way around. There can be no recovery of moral damages because here mutual love has intervened. However, moral damages may be recovered with the girl if the man makes efforts to make the girl withdraw a suit for support of the child repeatedly calls the attention of the girl's employer to her condition as an own and mother, a maneuver causing her mental anguish and even physical illness and suffering. Two, for actual damages, should there be any such as expenses for the wedding preparation. So in the case that there has been no carnal knowledge, there may be an action for actual and moral damages under certain conditions, as when there has been deliberate desire to inflict loss or injury, or when there has been an evident abuse of right. Thus, a man who deliberately fails to appear at the altar during the scheduled wedding simply because it was his intention to embarrass or humiliate the girl, no doubt inflicts irreparable injury to her honor and reputation, wounds her feelings, and leads the way for possible social ostracism. The girl in such case can recover not only actual but also moral and exemplary damages. Article 22. Article 22. Every person who, through an act or performance by act of performance by another or any other means acquires or comes into possession of something at the expense of the latter without just or legal ground shall return the same to him. Duty to return what was acquired unjustly or illegally. So this article talks about unjust enrichment. So no person should unjustly enrich himself at the expense of another. Example, A owed B a sum of money, evidenced by a promissory note. At maturity, A paid, and a receipt was given him. When later on he was again asked to pay, he could not find the receipt. So to avoid trouble, he paid again. So subsequently, he found the missing receipt. Can he now get back what he had intentionally paid? The answer is yes. In view of Article 22, which incidentally treats of an action in rem reverse. The essential requisites of an action in reversal that one party must be enriched and the other made poorer. And there must be a causal relation between the two. Article 23. Article 23. Even when an act or event causing damage to another's property was not due to the fault or negligence of the defendant, the latter shall be liable for indemnity if through an act or event he was benefited. Duty to indemnify because of benefit received. Unless there is a duty to indemnify, unjust enrichment will occur. Example, without A's knowledge, a flood drives his cattle to the cultivated highlands of B. A's cattle are safe, but B's crops are destroyed. True, A was not in fault, but he was benefited. It is but right and equitable that he should indemnify. Article 24. In all contractual property or other relations, when one of the parties is at a disadvantage on account of his moral dependence, ignorance, indigence, mental weakness, tender age, or other handicap, the courts must be vigilant for his protection. Reasons for the court's protection of the underdog. The law takes great interest in the welfare of the weak and handicapped. Thus, we have parens patriae. Parens patriae means the father or parent of his country. The state, as parens patriae, is under obligation to minimize the risk to those who, because of their minority, are as yet unable to take care of themselves fully. Article 25. Thoughtless extravagance and expense for pleasure or display during a period of acute public want or emergency may be stopped by order of the courts at the instance of any government or private charitable institution. Reasons for curtailing thoughtless extravagance. Thoughtless extravagance during emergencies may incite the passion of those who can't afford. Who can bring the action? Only a charitable institution, whether government or private, may bring the action. The mayor of a city, should he desire to stop an alleged display of extravagance by a social organization, cannot summarily order the stopping order himself. He has to ask for the court's order. A mayor indeed cannot just take the law into his own hands, no matter how noble or sincere his motive may be. Article 26. Article 26 states that every person shall respect the dignity, personality, privacy, and peace of mind of his neighbors and other persons. The following and similar acts, though he may not constitute a criminal offense, shall reduce the cause of action for damages, prevention, and other relief. Prying into the privacy of another's residence. 2. Meddling with or disturbing the private life or family relations of another. 3. Intriguing to cause another to be alienated from his friends. 4th, vexing or humiliating another on account of his religious beliefs, lowly station in life, place of birth, physical defect, or other personal condition. Duty to respect dignity and privacy. This article enhances the human dignity and personality. Personal equality is not sought, but due regard for decency and propriety. Remedies is talks about first an action for damages, B an action for prevention, and C any other relief. A civil action may be instituted even if no crime is involved, and moral damages can be obtained. Prying into the privacy of another's residence includes, by implication, respect for another's name, picture, or personality, except insofar as it is needed for publication or of information on pictures of legitimate news and values. Meddling with or disturbing the private life or family relations of another includes alienation of the affections of the husband or the wife. Thus, a girl who makes love to a married man, even if there be no common relations, to family life, and damages may therefore be asked of her, intriguing against another's honor, also included. Intriguing to cause another to be alienated from his friends includes gossiping or lying. Heresy. Vexing or humiliating includes criticism of one's health or features without justifiable legal cause. Religious freedom does not authorize anyone to keep looking and dispute upon another by reason of religious. Oh, that was religious. Article 37. Any person suffering material or moral loss because a public servant or employee refuses or neglects without just cause to perform his official duty may file an action for damages and other relief against the latter without prejudice to any disciplinary and administrative action that may be taken. Article 28. Article 28. Unfair competition in agricultural, commercial, or industrial enterprises or in labor through the use of force, intimidation, deceit, machination, or any other unjust, oppressive, or high-handed method shall give rise to a right of action by the person who thereby suffers damages. Article 29. When the accused in a criminal prosecution is acquitted on the ground that his guilt has not been proved beyond reasonable doubt, civil action for damages for the same act or omission may be instituted. Such action requires only a preponderance of evidence. Upon motion of defendant, the court may require the plaintiff to file a bond to answer for damages in case the complaint should be found to be malicious. If in a criminal case the judgment of an acquittal is based upon reasonable doubt, the court shall so declare. In the absence of any declaration to the effect, it may be inferred from the text of the decision whether or not the acquittal is due to the ground. Article 30. Article 30, when a separate civil action is brought to demand civil liability arising from a criminal offense, and no criminal proceedings are instituted during the pendency of the civil case, a preponderance of evidence shall likewise be sufficient to prove the act complained of. Article 31. Article 31, when the civil action is based on the obligation not arising from the act or omission complained of as a felony, such civil action may proceed independently of the criminal proceedings, and regardless of the result on the matter. So, as in Article 29, this Article 30 describes of the independent civil action. Meaning of independent civil action. Independent civil action is the one that is brought distinctly and separately from criminal case, allowed for consideration of public policy. The proof needed to a civil case is less than the required for the criminal cases, but with the injunction in general that success in financially recovering in one case should prevent the recovery of damages in another. It should be noted that the bringing of the independent civil action is permissive, not compulsory act. 32, 34, and 2177 gives instances of independent civil action. Instances when the law grants an independent civil action. Article 32 is talking about the breach of constitutional and other rights. Article 33 talks about defamation, fraud, physical injury. Article 34, refusal or failure of city or municipal police to give protection. Article 2177 talks about quasi-delict or culpa affiliate. Scope of Article 31, obligation not arising from crime. Article 31 contemplates a case where the obligation does not arise from a crime but some other act like contract or legal duty. Article 32. Any public officer or employee or any private individual who directly or indirectly obstructs, defeats, violates, or in any manner impedes or impairs any of the following rights and liberties of another person shall be liable to the latter for damages: freedom of religion, freedom of speech, freedom to write for the press or to maintain a periodical publication, freedom from arbitrary or illegal detention, freedom of suffrage, the rights against deprivation or property without due process of law, the rights to just compensation when private property is taken for public use, the right to the equal protection of the laws, the right to be secured in one's person, house, papers, and effects against unreasonable searches and seizures, the liberty of abode and unchanging the same, the privacy of communication and correspondence, the right to become a member of association or societies for purposes not contrary to law, the right to take part in a peaceable assembly to petition the government for redress or grievances, the right to be free from involuntary servitude in any form, the right of the accused against excessive bail, the right of the accused to be heard by himself and counsel, to be informed of the nature and cause of that decision against him, to have a speedy and public trial, to meet the witnesses face to face, and to have compulsory process to secure the attendance of witness and his behalf, freedom from being compelled to be witness against oneself, or from being forced to confess guilt, or from being induced by a promise of immunity or reward to make such confession except when the person confessing becomes a state witness, freedom from excessive fines or cruel and initial punishment unless the same is imposed or inflicted in accordance with the statute, which has not been judicially declared unconstitutional, and freedom of access to the court. In any of the cases referred to in this article, whether or not the defendant's act of omission constitutes a criminal offense, the aggrieved party has a right to commence an entirely separate and distinct civil action for damages and for other relief. Such civil action shall proceed independently of any criminal prosecution if the latter be instituted and may be proved by the preponderance of evidence. The indemnities include moral damages. Exemplary damages may also be adjudicated. The responsibility herein set forth is non-demandable from a judge unless its act or omission constitutes a violation of the penal code or other penal code. Article 33. Article 33, in cases of defamation, fraud, and physical injuries, a civil action for damages entirely separate and criminal action may be brought by the injured party. Such civil action shall proceed independently of the criminal prosecution and shall require only a preponderance of evidence. Independent civil action for defamation, fraud, and physical injuries. Article 33 speaks of defamation or libel or slander or intrigue against honor, fraud, or staff or brandy. Physical injuries including consummated, frustrated, and attempted murder, parricide, infanticide, so long as there was physical injury. New concept of tort. By virtue of this article, torts in the Philippines are now of two kinds, namely, an American concept of tort, which is done maliciously or intentionally. The Spanish concept of tort, culpa, appellana, or quasi delict, which is based on negligence. According to the Code of Commission, this separate civil action is similar to the action on torts for libel and slander, deceit, and assault, and battery under the American law. Article 34. When a member of a city or municipal police force refuses or fails to render aid or protection to any person in case of danger to life or property, such peace officer shall be criminally liable for damages, and the city or municipality shall be subsidiarily responsible therefor. The civil action herein recognized shall be independent of any criminal proceedings, and the preponderance of evidence shall suffice to support such action. Independent civil action for the liability of city or municipal police force. We have here primary liability is assessed against the member of the police force who refuses or fails to render aid or protection. Subsidiary liability is imposed on the city or municipality concerned in case of insolvency. Does this article apply to the Philippine police force of the national government? Since Article 34 speaks merely of the city or municipal police force, it would seem that the answer is in the negative. Article 35. When a person claiming to be injured by a criminal offense charges another with the same for which no independent civil action is granted in this code or any special law, but the justice of the peace finds no reasonable grounds to believe that the crime has been committed, or the prosecuting attorney refuses or fails to institute criminal proceedings, the complainant may bring a civil action for damages against the alleged officer. Such civil action may be supported by the preponderance of evidence. Upon the defendant's motion, the court may require the plaintiff to file a bond to indemnify the defendant in case the complaint should be found to be malicious. If during the pendency of the civil action an information should be presented by the prosecuting attorney, the civil action shall be suspended until the termination of the criminal proceedings. Rule if no independent civil action is granted. This article applies to cases where there is no independent civil action, such as when the liability sought to be recovered arises from crime, and not to a tortious action such as that provided for under Article 36. Article 36. Prejudicial questions, which must be decided before any criminal prosecution may be instituted or may proceed, shall be governed by rules of court which the Supreme Court shall promulgate and which shall not be in conflict with the provisions of this code. Definition of a prejudicial question. A prejudicial question is one which must be decided first before a criminal action may be instituted or may proceed because a decision therein is vital to the judgment in the criminal case. The prejudicial question must be determinative of the case before the court. For the court, this is the first element. Jurisdiction to try said question must be lodged in another tribunal. This is the second element. Indeed, for a civil case to be considered prejudicial to a criminal action as to cause the suspension of the latter, pending the final determination of the former, it must appear not only that the civil case involves the same facts upon which the criminal prosecution would be vague, but also that in the resolution of the issues raised in a said civil action, the guilt of innocence of the accused would necessarily be determined. In an action for bigamy, for example, an accused claims that the first marriage is null and void, and the right to decide such validity is vested in another tribunal. Civil action for nullity must first be decided before the action for bigamy can proceed. Hence, the validity of the first marriage is a prejudicial question. Yeah, the prejudicial question is a question which is based on facts distinct and separate from the crime, but so intimately connected with that its resolution is determinative of the guilt of or innocence of the accused. The criminal action, it must be appeared not only that the civil case involves facts intimately related to those upon which the criminal prosecution is based, but also that the decision of the issue or issues raised in the civil case would be decisive of the guilt or innocence of the accused. Requisites of prejudicial question. First, the civil case involves facts intimately related to those upon which the criminal prosecution would be based. Second, in the resolution of the issues or issues raised in civil actions, the guilt or innocence of the accused would necessarily be determined. And third, jurisdiction to try said question is lodged in another tribunal. Let's go to Book 1 Persons, titled Civil Personality. Chapter 1, General Provision. Person. Person in any being, natural or artificial, capable of possessing legal rights and obligations. Two kinds of persons. First, natural persons, human beings created by God through the intervention of the parents. Judicial persons, those created by law. Article 7. Juridical capacity, which is fitness to be the subject of legal relations, is inherent in every natural person and is lost only through the death. Through death, capacity to act, which is in the power to do act, in legal effect, is acquired and may be lost. Definition of juridical capacity: the fitness to be subject of legal relations. Definition of capacity to act: the power to do act with legal effect. Differences between juridical capacity and capacity to act. We have here table juridical capacity and capacity to act. For juridical capacity, passive. For capacity, it can be active. Inherent, merely acquired. Lost only through death. Lost through death and may be restricted by other causes. Can exist without capacity to act. Exists always with juridical capacity. Article 38. Article 38, minority, insanity, or imbecility. Imbecility. The state of being deaf, mute, prodigality, and civil interdictions are mere restrictions on capacity to act. Do not exempt the incapacitated person from certain obligations when the latter arise from his acts or from property related, such as these. Article 39. The following circumstances, among other, modify or limit capacity to act: age, insanity, imbecility, and state of being a deaf mute, penalty, prodigality, family relations, alienage, absence, insolvency, and trusteeship. The consequences of these circumstances are governed in this code. Other codes, the rules of court, and in special laws, capacity to act is not limited on account of religious belief or political opinion. A married woman 21 years of age or over is qualified for all acts of civil life except in cases specified by law. Chapter 2. Natural persons. Article 40. Birth determines personality. When a conceived child shall be considered born for all purposes that are favorable to it, provided it be born later, with the conditions specified in the following articles. Beginning of personality. Personality does not begin at birth. It begins at conception. This personality at conception is called presumptive personality. It is, of course, essential that birth should occur later. Otherwise, the fetus would be considered as never having possessed legal personality. From, of course, another viewpoint, we would say that personality or actual personality really commences at birth. For conception may, in certain cases, be already considered birth. Article 41. For civil purposes, the fetus is considered born if it is alive at the time it is completely delivered from the mother's womb. However, if the fetus had an intrauterine life of less than 7 months, it is not deemed born if it dies within 24 hours after its complete delivery from the maternal womb. Article 42. Civil personality is distinguished by the effect of death upon the rights and obligations of the deceased is determined by law, by contract, and by will. Article 43. If there is doubt as between two or more persons who are told to succeed each other as to which of them died first, whoever alleges the death of one prior to another shall prove the same. In the absence of proof, it is presumed that they died at the same time. There shall be no transmission of rights from one to another. Exemptions from survivorship under revised rules of court. So when two persons perish in the same calamity, such as a wreck, battle, or conflagration, and it's not shown who died first under no particular circumstances from which it can be inferred, the survivorship is assumed from the publicities resulting from the strength and age of the sexes according to the following rules. Both were under the age of 15 years, the older is presumed to have survived. If both are above age of 60, the younger is presumed to have survived. If one be under 15 and other above 60, the former is presumed to have survived. If both be over 15 and under 60, the sexes be different and the male is presumed to have survived. If the sexes be the same, the older can be older. If one be older, under 15 or over 60, the other between those ages, the latter is presumed to have survived. Chapter 3. Juridical person. The following are juridical persons: the state and its political subdivision, other corporations, institutions, and entities for public interest or purpose, created by law, their personality begins as soon as they have been constituted according to the law. Corporations, partnerships, and associations for private interest or purpose to which the law grants a juridical personality is separate and distinct from that of its shareholder, partner, and member. Classifications of juridical persons. There are two kinds of juridical persons: public juridical persons and private juridical persons. Public corporations like province and the city. The state itself. Private juridical persons, private corporations, partnerships, and foundations. The Church. The Roman Catholic Church in the Philippines is a person, but it is an entity or person separate and distinct from the personality of the Pope or the Holy See. The Roman Catholic Church already is incorporation souls during the politics of the Philippines can therefore acquired lands in our country. The Roman Catholic of a parish, however, are not a juridical person, there being no provision of law for the organization as one. Article 45. Juridical persons mentioned in numbers 1, 2 of the preceding articles are governed by laws creating or recognizing them. Private corporations are regulated by laws of general application on the subject. Partnership and associations for private interest or purpose are governed by the provisions of this code concerning partnership. Determination of nationality of juridical person. Nationality of corporation is generally determined by the place of its incorporation. So, if incorporated in the Philippines, this Philippine corporation. So, exemption may for certain purposes be made to this rule, namely, for grant of rights in the Constitution during war. Article 46. Article 46. Juridical persons may acquire or possess property of all kinds, as well as incur obligations and bring civil or criminal actions in conformity with the laws and regulations of their organization. Rights of juridical persons to acquire or possess property. Article 47. Article 47. Upon the dissolution of the corporations, institutions, and other entities for public interest or purpose mentioned in numbers 2, Article 44, the property and other assets shall be disposed of in pursuance of law or the charter creating them. If nothing has been specified on this point, the property and other interests shall be applied to similar purposes for the benefit of a region, province, city, or municipality which during the existence of the institution derive the principal benefit for the state. That is Civil Code of the Philippines, Article 1. So Article 1. Thank you for listening.
So a few weeks after